Good evening, noble lords. Good evening, highly esteemed. Good evening, your excellencies and special ADR enthusiasts. It is awesome having you join us in this webinar on the platform of Association of Multi-Door Courthouse Practitioners. We are happy you could join us. It promises to be a very interactive, informative, and enlightening session. And we do hope that at the end of today's webinar, there will be need for us to be more focused and to be realigned towards achieving the objectives of the association and ADR in general. We are delighted to have someone very special as far as ADR is concerned, national, locally, and internationally. And in due time, we will bring him on the call. Please, before we bring in our guest for tonight, allow me to share my slide as we take a little intro into the business of today. Welcome to this webinar with the theme, the Arbitration and Mediation Act 2023. How far so far? With us today is none other than Isaiah Bozimo, SAN. He will be on the call tonight. Talking about the Association of Multi-Door Courthouse Practitioners. The Association of Multi-Door Courthouse Practitioners was established on the 11th day of November 2022 as an umbrella body for accredited alternative dispute resolution practitioners by Mr. Valentino Burrow, attorney mediator and pioneer mediation advocate in Nigeria. Mr. Burrow reasoned that mediators, mediation advocates, as well as restorative justice practitioners and arbitrators who practice at the multi-door courthouses require a common platform where they can interact, share practice nuggets, as well as set professional standards for themselves. Membership of the association is open to both lawyers and non-lawyers who are qualified by training and accreditation to practice in any multi-door courthouse or other amicable dispute resolution fora. Initial membership of the association stood at 100, drawn from different institutes, including the Institute of Chartered Mediators and Conciliators, ICMC, Attorney Mediators Association. We have the Standing Conference of Mediation Advocates. We have the Nigerian Institute of Chartered Arbitrators, Institute of Chartered Arbitrators, Lagos State Multi-Door Courthouse, the Edo State Multi-Door Courthouse, Settlement House ADR Training Institute, and other multi-door courthouses, not forgetting other independent practitioners who signed up by way of formal application to become members. The association will be a bulwark of support for multi-door courthouses and its practitioners in the face of challenges. The association will also vigorously advocate for the uptake of ADR processes as a viable option for the resolution of legal disputes and the conjunction of conventional courtrooms. Noble lords, your excellencies, highly esteemed ADR enthusiasts, it is delighting to bring on board our very special guest for tonight, no other than Isaiah Bozimo, SAN, a former Delta State Attorney General. Permit me to go through his profile. Isaiah Bozimo, SAN, the former Delta State Attorney General, has significantly influenced commercial arbitration and dispute resolution across Africa. He introduced important legal reforms, including the Delta State Arbitration Law of 2022, and played a key role in shaping Nigeria's Arbitration and Mediation Act. Currently, our special guest tonight is a partner at Broderick, Bozimo and Company. Our special guest applies his extensive experience in representing various clientele, including government bodies, corporations, and individuals locally and internationally. He is highly regarded for his skill in settling complex commercial disputes. Our special guest, Isaiah Bozimoesian, his impressive case portfolio includes significant cases such as a $2 billion claim involving an international trade center and a $300 million dispute over gas supply under the ICC arbitration. He is recognized by Who is Who Legal and African Arbitration Academy. He is a chartered arbitrator and fellow of the Chartered Institute of Arbitrators. He is also a panel member at several esteemed arbitration centers in Singapore, South Africa, Lagos, and Kigali. Our special guest today also actively contributes to key publications that guide remote dispute resolution and international arbitration practice. He is a prominent voice in advancing effective commercial dispute resolution in Africa. Noble Lords, Your Excellencies, I'm delighted to bring on board today Isaiah Bozimo, SAN. It's a delight having you join us, sir. You're most welcome, sir.
Thank you very much. I should begin by giving my sincere thanks to the Association of Multi-Door Courthouse Practitioners for inviting me for this conversation. I very much look forward to it. I'm delighted to see we have over 40 individuals joining us on this call. I'm very esteemed, each and every one of you. I look forward to having a conversation with you. As my good friend has said, we want to make the conversation as interactive as possible. So I hope you will permit me, as you ask me questions, to also throw some questions back to you, because I would love to know how you also work through certain problems, and together I'm sure we'll make it as insightful a conversation as possible. So thank you very much once again.
Thank you so much, sir. It's an honor having you join us. To begin the conversation for the day, please permit me to ask you, if you don't mind. The Arbitration and Mediation Act has come as a revolutionary piece of legislation designed to broaden and simplify access to justice in our country. 1 year down the line, so far, so soon, is already a year old as far as we are concerned. Is there any glimmer of hope that the objective of drafting this act will be achieved?
Okay, very interesting question. And as you were reciting that question to me, the first question that came to my mind is, what do we mean by access to justice? I ask because I find from experience that as practitioners, we have a very nuanced definition of what access to justice entails. So for instance, you will see from many judicial authorities that access to justice is traditionally equated as being in access to the courts. So if you ask most practitioners, and I have done this, and I say, what do you understand by access to justice? Immediately they will say access to the courts. Well, there's a problem with that, because if you equate access to justice as access to the courts, then it ignores the inefficiencies that occur after you've accessed the courts. And the example I always give is the case of Shell versus Anaro. It's a case I was involved in at the Supreme Court level, but it's a case that actually started when I believe I was not up to 1 year old. My parents started that case. It went through the High Court of Bendel State. Judgment was delivered in the High Court of Delta State in 1991, I believe. In 2002, there was a decision of the Court of Appeal that affirmed it. 2002, I think I was almost finished with university, case that started when I was just 1 year old. And then it went on to the Supreme Court. And in 2015, when I was around 34, I argued that case at the Supreme Court. So one would then ask is, you have a judgment of the Supreme Court, but do the plaintiffs really have access to justice, particularly when you consider the fact that by the time the Supreme Court judgment was delivered, over 70% of the plaintiffs were deceased. The value of the judgment had significantly depleted because of inflation. So ask yourself that question again. What does access to justice mean? And I think we need to reframe that concept between access by individuals and businesses to effective means of not only accessing a process to resolve their disputes, but actually obtaining an effective resolution to their disputes. So that is what arbitration seeks to do in general, particularly in the context of cross-border transactions. That is to say, if you have, for instance, a business that is in Nigeria doing a contract with a business in Malawi, and a dispute arises between the two of them, traditionally, both of them would be reluctant to go to each other's courts. As a Nigerian, you might be reluctant to go and resolve your dispute before the Malawian courts, and vice versa, because we are not familiar with those practice and procedures. So arbitration or even mediation steps in as a middle ground. That is to say, we agree on the process through which our dispute will be resolved. And so why the Arbitration and Mediation Act? Well, the Act has really updated and advanced Nigeria as one of the jurisdictions that has a very modern arbitration law. And we can discuss the significance of that as the conversation progresses and evolves. But does the Act in and of itself guarantee access to justice? The answer will be no. The Act gives you a platform through which you can obtain access to justice. Our application of the Act is what is critical. So 1 year down the line, what has been the application of this Act? Again, it would depend. It would depend on who you ask, which court you come before. So for instance, I've seen many cases in which the Arbitration and Mediation Act has been applied very, very skillfully and very purposefully to reach an effective resolution to the parties' disputes. And I've seen courts resolve the dispute in terms of enforcement of the award relatively quickly. But what is more concerning is that I've also seen the opposite. I've seen parties deliberately stifle the arbitration process. I've seen courts that are not assisting the arbitration process, but are rather hindering the arbitration process. So in order for us to get to this promised land, if I can describe it like that, we need not only legislative reform, in which the Arbitration and Mediation Act does, but we also need a shift in our mindset to know what the objectives of arbitration are, what the objectives of mediation are, and to ensure that our application of those objectives through the Arbitration and Mediation Act really fulfill the objectives for which the act was, which the enactment was made in the first place. So that's a very long-winded way of saying the jury is still out. The potential is there for the act to really broaden access to justice, broaden the means through which businesses and individuals can not only access but obtain justice to an effective resolution to the disputes they face. So I hope that answers your question. If there's a follow-up, please feel free to ask. And likewise, if any members of the audience have a follow-up, please feel free to just put it in the chat. I'm really eager to make this a two-way conversation. So I hope that one answers the first question.
Thank you so much, Leonard Sig, for that insightful and thought-provoking response. We appreciate the dynamism in which you have looked at the issue. Permit me to talk about this controversial topic a little bit. Most legal practitioners see ADR as an opportunity for alarming drop in revenue. And to this extent, they may be, they may not be positively disposed to promoting the practice of ADR. Permit me to ask, if you don't mind, does the AMA 2023 in any way address this issue of apathy towards ADR from the legal practitioner?
Yes, it's one I've heard very frequently. That is to say, the equation of ADR to alarming drop in revenue. It needn't be so. But I think this is an opportunity to know how perhaps some members of our very esteemed audience deal with issues of pricing. So let me just ask, I presume that me, if not, let me say most, if not all members of the audience are legal practitioners, or at least in the legal community. If I'm correct, just drop yes in the chat. If you are a lawyer, practitioner, just indicate. I just want to have an idea of something. Please oblige me. Don't be shy. Oh, nobody wants to talk to me today. Not all, no, certainly not all of you. Certainly not everybody is a legal practitioner, but I will presume many of us are lawyers. And
some responses are coming in Glenn on the
oh, there
chat
are.
box.
Okay, great. I've seen one so far. But let me sort of advance my thinking a little bit. Now, many lawyers I usually ask you, well, how do you, when it comes to pricing a matter you have, a client that you have, how would you price it? And many of them will tell me, for instance, oh, well, it depends. So maybe the number of times I need to go to court, the number of juniors involved in the case, and different matters like that. But I find that to be an efficient way to price a case in which you're involved, because we as lawyers or as dispute resolvers, we are in a very privileged position in the sense that when somebody comes to me as a lawyer, I know that they are at a pain point, right? The existing position in which they find themselves is giving them significant discomfort. If not, you don't need a lawyer. You don't need to go to court in order to resolve that thing that is disturbing you. So that's the beginning point. I also know that they want to get to a desired future state. And that desired future state is one in which the legal problem they're facing goes away. Now, 9 out of 10 times, particularly if you're in arbitration or in commercial mediation, the person who comes to you would be a business. Now, think about this. What would be the number one value proposition that a business would want in coming to you as a dispute resolver? And again, please feel free to drop your different ideas in the chat. But if you tell a business that, okay, I'm happy to take your case to court, maybe in the high court, we might be there for approximately 2 or 3 years. There's a possibility of an appeal, Court of Appeal, we might spend another 3, 4 years. There's a possibility of another appeal to the Supreme Court. Supreme Court, we will spend maybe 5 or 6 years, depending on how the cases are progressing. And, I've looked at your case. In the circumstances, I'm going to charge you 20 million naira. Now, to that business that you've just described that process to, 20 million naira does not seem like good value. Because if you're a business, what is important to you is not spending time in the courts, but spending time improving and upgrading your business, focusing on what really matters to you, which are your clients. Now, if I say to a business person, okay, I have a way or a method through which you can resolve this dispute in 9 months, right? But in that 9 months, I think it will cost you 30 million naira. Would the business go for that? Typically, the average business will say, no, that's too much. I can go and meet, lawyer B who will charge 2 million naira and thereabouts. But you need to contextualize the conversation. And I'll give you a real life example. So one of the very first arbitrations I did when I left my principal, Patrick Ikweto, Senior Advocate of Nigeria, when I left that firm in 2017 to start there was an arbitration I did. It was a power supply dispute. And I recall having an initial conversation with the client, and we were discussing fees. And the client at the time was not willing to go over a certain amount. I won't disclose what that amount is, but let's call it 5 million naira, right? And we had to really contextualize the conversation. So I said, okay, explain to me the problem you are having. And they said, well, it's a business we have with a very significant counterparty. And if this business does not continue, we will lose a lot of money. Okay, how much money will you lose? We will lose somewhere in the region of 10 billion naira. So the next question was, well, if you had a chance to solve that problem in a few months, would 10% of 10 billion naira be an amount you'll be willing to pay to save this business? And naturally, they will say yes. It's a no-brainer, right? 10%, so 200 million naira to save a 2 billion naira problem. And then you then progress the conversation even more. You say, well, okay, good news. It will not cost you 10%, right? It might not even cost you 0.5% or 0.1%. But you have to be able to make the client know that the value of what you're charging is proportionate, the amount you're charging is proportionate to the value they will receive. And ADR gives a significant value. In fact, for most clients I represent, they will pay me more to resolve the dispute in a shorter period than they would want to go into court and having the dispute stretch out for a number of years. And I will, let me not say guarantee, I would wager that most businesses will think the same way. So does ADR amount to an alarming drop in revenue? It ought not to, but you have to make the client know that the value of your offerings translate to the value of what they will receive. So don't look at money in a way that you say, okay, I'm equating money to the number of appearances I make. I'm equating money to the number of processes I have to file. Look at the money you charge as reflecting the value that the client will receive, the value of coming from the initial pain point to the desired future state. And if they see significant value in that, they will be prepared to pay a lot of money in that. And I know very many successful ADR practices. And I'm sure many of them are in this room, including the esteemed moderator as well, who's now smiling at me.
Thank you so much, Leonard. I'm glad to know that we have honorable justices on the call. We also have legal practitioners on the call. I think at some point you asked a question for legal practitioners to confirm that they are part of us, and they did drop their chat message informing us that they are here. Do you want to pose a question and leave the floor open for interactions as regards how they communicate fees with their clients and their perspective of the implication of ADR vis-a-vis their revenue?
Sure. I mean, I'd be very interested in knowing, because this is the way we all learn. I would be interested in knowing, first of all, okay, so the first question I would ask is, if a client comes to you with a dispute, or if you're in the position to resolve a dispute, would you charge your client more to go to litigation, that is to go to court, or to go to ADR? Would you charge your client more? And the second question might be, well, how do you base the fees you will charge? So if I can get some insights, that would be very useful for me in terms of framing my approach and see if we can assist each other in ensuring that ADR doesn't equate to an alarming drop in revenue. And actually, there was a conversation I had with some lawyers in Enugu, and the response they will usually give is that, oh, well, it's easy for you to say so. You've taken silk, you can charge significant amounts of money. Well, I took silk. Yes, I've taken silk, but it's not been up to 1 year. I took silk. I took silk in November of last year. And most of my experiences are actually from cases I did, matters I did before I became a senior advocate of Nigeria. In fact, some of them years and years and years before I became a senior advocate of Nigeria. And it's because I took a different approach to the way I communicated the value of what I'm charging to clients. So I'd be very interested in knowing what our audience thinks. Do you think that's a good idea? Do you take a different approach? Please let me know. I'll be interested in knowing.
I think at this point, the floor is open to ADR assessors and legal practitioners, your relationship and your experiences you may have had with clients vis-a-vis fees for ADR processes. Please, you can raise your virtual hand and we give you the floor. It promises to be very interactive. Wow. Your Excellencies, our noble ambassador of appreciation and President MTI Nigeria, Your Excellency Ambassador Ogunyoro, the floor is yours. Please unmute and share your thoughts.
Thank you so very much. Your Excellency, the Learned Circ, I'm excited to be listening to you. I've told myself tonight I must be available to hear the great man speak. Very quickly, when we train legal practitioners, and we're talking about fees, I normally would ask them to charge normally the way they would charge for the case to go to court, and maybe give an idea of how long it would take, maybe 2-3 years, and then ask a simple question. Supposing I can get this dispute resolved in a month, maximum 3 months, how much more will you be willing to pay? Not how much less, because most times we talk about the fact that if a lawyer tells his client that there are ways that are faster, that are cheaper, that will preserve the dispute relationship, the client will know that you have his best interest at heart. So that's the general concept. But when we're talking about time value of money, like you've been saying, Excellency, it's better for them to appreciate ADR as express service. So if I'm going to get this resolved in a shorter time, how much more will you be willing to pay? And once you have a track record of speedy resolution of a dispute, that your client becomes your natural advocate, telling other people that you can get this dispute resolved speedily, even though it's going to cost a little more. And they want to go back to their business. So like you said, access to justice, not just access to the courts. Providing access to justice means providing access and opportunity for a timeous, cost-effective, and user-friendly access to justice. Thank you for this opportunity. I appreciate it. Thank you, Excellency. Thank you.
Thank you so much, Ambassador Ogunyoro, a great man. Thank you so much, sir. I think our guest will be disposed to taking 1 or 2 more thoughts from participants. Please, if you wish to share any experience, please feel free to raise your virtual hand and we'll do well to bring you on board. Do we have any legal practitioner, any ADR enthusiast that wishes to share experience as far as fees for ADR is concerned? Thank you, Chidi Ezehi. The floor is yours. Please unmute and share your thoughts.
Thank you for having me. I want to count myself blessed for being a participant of this section. I want to thank the learned Sikh for taking his time to take us through this section. I really appreciate you. Thank you very much, sir. From my personal experience, in fact, if I want to be sincere with you, the sweetest money I've made this year from my practice as a legal practitioner, as a private legal practitioner, comes from ADR. The reason being that my client is not based in Nigeria here. And when he came back from the States, the first thing he told me that he's disappointed with the system of litigation in Nigeria, that it lasts so many years and all that. So he now asked me, is there any way he can get justice as soon as possible? I told him, I said, yes. He said he wouldn't mind to pay anything. He said any amount, as long as he can get access to justice as soon as possible. And I said, okay, fine. There's what we call the ADR, Alternative Dispute Resolution. If you don't mind, can we approach them through one of the mechanisms of ADR? He said I should explain better. I explained to him that we can use mediation and all that. So before you know it, we set the ball rolling. And the first section, he was impressed. So he now said that we have not discussed the price though. I said, well, my price will go by percentage because it was recovery of property, and for me to ascertain the value of the property, I engaged an estate valuer who valued the property and gave us the estimated value. And as God may have it, the man didn't hesitate to pay the required percentage, which I wouldn't want to mention here for some reasons. The next 3 sittings of that section, party resolved the issue. In fact, it was a win-win situation. And I made my money that, in fact, most of my matters in high court, even in court of appeal, have spent so many years. No resolution of the matter, no judgment has been given, but within a space of 3 sittings, my client got what the desired result, and he was happy. And he added extra money. He added extra money to it. He added extra money to show appreciation. So for me, I don't see ADR as a way of losing income. Rather, lawyers should embrace ADR so that many people will have access to justice, even without having the monetary benefits, in the mind. They should go ahead to liberate, make justice a free, in fact, make the world a free place so that everybody will be happy. Thank you.
Thank you so much, Chidi Eze Esquire. Thank you for that remarkable experience. Finally, before we proceed, if our special guests do not mind, Ambassador Michael Agbabia Jays, your hands has been up and you will have the floor. We'll quickly take comments from you and we'll make progress. Please unmute and share your thoughts as regards the issues on the floor. Thank you.
Thank you, sir, Your Excellency. My greetings to our guests.
Ambassador, it seems as if we're having network glitch. Let's see. I think we're going to create an opportunity for Ambassador Michael to come back with that his question or his comment. If you don't mind, can we make progress looking at the
Thank you, sir.
arbitration?
Thank you to our convener and
Thank you so much, Ambassador Michael. Thank you. Now, let's see, if you don't mind, I think we need to look at the Arbitration and Mediation Act. What flavor has it brought to the world of ADR? What dynamism has it brought? What zeal? What's the advantage of AMA 2023? What has made it better off than the way it was before AMA 2023 came on board? The floor is yours.
Thank you. I think that's an excellent question. In fact, in the process of drafting the Arbitration and Mediation Act, somebody asked, okay, well, what's wrong with the Arbitration and Conciliation Act of 1988? Well, what's actually wrong with it? Because at the time the ACA was enacted, it was based on the 1985 version of the Model Law, which was the gold standard of international arbitration. Because the idea being, and I'm sure many in the audience already know this, but the advantage of those who might not, the UNCITRAL Model Law came about because of the issue of cross-border dispute resolution. Before uniform arbitration laws, you would have, well, I explained the problem you might have in going to litigation in two different jurisdictions. You are simply not familiar with those processes, and then you're reluctant to do so. Believe it or not, there was a similar problem with arbitration in the sense that country A might have one arbitration law that prescribes a given set of procedures, and country B would have something entirely different. And for a business person, that is not satisfactory, because if there's one thing that businesses want, it's certainty, it's predictability, particularly if you are answerable to shareholders, you are answerable to clients, and you are looking after their interests. So they always want predictability so they can budget and they can get on with the business, with the business of running their business. So having fractured arbitration laws was not a satisfactory outcome. So the United Nations Commission on International Trade Law came up with the model law. The idea being that different jurisdictions could adopt the model law provisions, and you would be considered to be a model law country if you adopt about 70 to 80% of those provisions. And the advantage is that irrespective of which country a business person goes to, they have the certainty that the arbitration laws and therefore the arbitration procedures would be the same and is therefore predictable, right? So the ACA took on the 1985 version of the UNCITRAL Model Law. But naturally, as time went on, businesses will advance. Businesses will become more complex. Let me give you one example. If you look at the definition of an arbitration agreement in the Arbitration and Conciliation Act, it will include an exchange of letters and telegrams. Somebody please tell me, when was the last time you sent a telegram? Or when was the last time you sent a handwritten business letter? We usually do it by email, by WhatsApp, or by some electronic medium. Now, ask yourself this question. If, for instance, we then had an exchange of emails that contained what we believe or what one party is saying is an arbitration agreement and the other party disputes it, would you have an arbitration agreement under the ACA when the ACA doesn't say exchange of emails but says exchange of letters and telegrams? Well, I can tell you the decisions have been mixed. There have been courts, international courts, that have said that an exchange of emails is not sufficient, is not envisaged by the 1985 version of the UNCITRAL Model Law, and therefore you don't have an arbitration agreement. That's a problem, right? Or take a situation where you have a very complex contract. You have a multinational construction contract, right? In the news, we've been seeing the Lagos-Calabar Expressway. Now, if you look at that, the contract, I guarantee you, well, you have an employer, which is the federal government of Nigeria. You will have a main contractor. You will have a subcontractor. You will have subcontractors, and it could go on like that. Now, at each level of the transaction, there is going to be a contract. And if they're sophisticated business people, there will likely be an arbitration agreement. Now, imagine you have main contract, subcontract, subcontract, each with arbitration agreements. Then there's a dispute now between the subcontractor and the subcontractor that affects the top level contract. The main contractor may then, or the employer might say, well, you're not delivering on the project. I'm going to sue you, main contractor. Meanwhile, the main contractor is not even a party to the dispute that is agitating this process, right? So what do? You would need a means to either consolidate different proceedings or to join a non-signatory to the arbitration agreement. So the arbitration, and there are many more examples I could give, but for the purpose of time, the Arbitration and Mediation Act brought the arbitration legislation in Nigeria up to date. That's a very simple way of putting it. It took account of the complexities of businesses. It took account of the peculiarity facing as a jurisdiction in Nigeria. And it ensured that there is a framework through which you can effectively resolve those disputes without getting into arguments as to whether you have a valid arbitration agreement, because it is done electronically by giving you a means for joiner and consolidation of parties. So the AMA is now modeled on the 2006 version of the ancestral model law, which includes many other things, one of which is interim, very, very important as a final award, if not important, because an interim measure seeks to protect the subject matter of the dispute. Think of it as protecting the res. Now, if you don't have a subject matter, then you will have a Pyrrhic victory. You will have an award, but nothing to enforce. So under the ACA, it didn't give a means through which you could enforce interim measures. And that was a bit of a problem because think about it, right? You make an interim application to the tribunal. You say, preserve the subject matter of the dispute pending the final award. The tribunal makes that interim measure for you. The other party is breaching, so you want to enforce. You have to go to the courts. And you will try and enforce it as an interim award, right? Again, there could be a problem there because the arbitration laws say that an award must be final. It can't be interim. By its very nature, an interim measure is not final. It is made pending the resolution of something. So you've had, for instance, the Australian High Court, which is the highest court in Australia, to say that interim measures are not enforceable in Australia because they're not final. So again, that was a bit of a problem. So the AMA provides a very comprehensive framework for the enforcement of interim measures. It is now there in legislation to say, these are the grounds on which you can enforce, and these are the grounds on which the interim measure will be refused recognition and enforcement. So extremely important in terms of bringing business practices up to date for dispute resolution purposes, and ensuring that Nigeria, again, is at par with international best practices in terms of incorporating the 2006 version of the ancestral model law. So let me pause for now so we can get other questions in.
Thank you so much, Leonard Sick. It's on record that you were critical to the drafting of the Arbitration and Mediation Act. So it's not surprising that there's so much to say, and we don't even know if we can have all that we need to have within the space of time for this webinar. But at this point, I think it would be instructive to hear from you. We do know that the conventional courts that ought to promote the process of ADR based on the fact that it is instrumental to reducing the court dockets. Most of the times they hold back to matters that they should have referred, subjecting parties to go through ADR. Do we have any provision in the Arbitration and Mediation Act that can compel judges, compel judicial officers to release matters for the purpose of being subjected to ADR?
Okay, again, a very important question. Important because if you ask yourself, or let me take a couple of steps back. Our desire as an ADR community is to ensure that Nigeria is a viable hub for ADR practices, arbitration, mediation, and other ADR practices. Why is that important? Because look at empirical data. Empirical data tells us that for cross-border business transactions, the preferred method is arbitration primarily, and now increasingly mediation, commercial mediation. Again, ask yourself, so what? Well, how does that affect me? Well, you may have seen in the news recently that we've signed a significant treaty called the Africa Continental Free Trade Area Agreement. By the time it comes on stream, it's going to create the largest free trade zone in the world. 54 countries in a free trade zone is the largest that would be anywhere in the world. Again, how does it affect you? Well, with increased trade comes the inevitable, increased disputes. And when you look at the data to say, well, statistically speaking, most of these people involved in these disputes do not want to come to the courts. Many of them will not even be Nigerian. So you need to have an arbitration system, a mediation system, an ADR system that is conducive, that tells the international community that you can come and resolve your disputes safely in this jurisdiction. Again, let me give you, and I like numbers a lot. I like talking with data. There was, I think it was around 2015, there or thereabouts, I was given a talk at one of the annual general conferences of the Nigerian Bar Association, and the topic was making a business case for arbitration and dispute resolution in general, alternative dispute resolution. And let me give you one statistic that will maybe shock you, maybe not. In that year, the United Kingdom made more in terms of GDP, contributions to GDP. They made more through their justice sector than Nigeria did through oil. They made more by people saying, I want to go to the UK to resolve my dispute, either by arbitration, even litigation, or ADR, than we made through selling oil. Now, consider that multiplier effect. You go and you litigate or arbitrate or mediate in a particular jurisdiction. You will need lawyers from that jurisdiction, so you're creating business. You will need accommodation in that jurisdiction, you're creating more business. You will need facilities in that jurisdiction, and so the list goes on. And then if you look at data from the Queen Mary International Arbitration Survey, it tells you that the most viable seats have 3 characteristics. I'm talking of viable seats in terms of arbitration. A modern arbitration law, which we now have, judicial non-interference, which is very key, because that's the reason you put an arbitration clause in your contract in the first place. And a high probability or a high percentage that your arbitration agreements and your arbitration awards will be enforced, right? Now, when you situate that within the question, you see why it is critically important that the courts are supportive of arbitration. For the most part, they are. They are. Again, we have looked at data from court-related decisions before, mainly before the appellate courts in Nigeria, Court of Appeal, Supreme Court. And I'm happy you said that we have honorable judges and hopefully honorable justices of the appellate courts on the call, because we would be really interested in knowing having access to arbitration-related decisions at the high court level. We don't have a lot of those, and I think it will really show that Nigeria, to a large extent, is an arbitration-friendly jurisdiction. But let me come back to my analysis. When you get one decision that is perceived as being anti-arbitration, it will gather significant attention, and it will have a negative effect on the reputation of our jurisdiction. So, for instance, I'm aware of decisions where parties have obtained injunctive reliefs from the court that will prevent not only the parties in arbitration, but also the arbitrators from continuing. And if the arbitrators continue, that's automatic contempt of court. And no arbitrator worth his salt or her salt will want to continue in those circumstances. Now, juxtapose that with what is supposed to happen. If you look at Section 5 of the Arbitration and Mediation Act, it says where the parties, and I'm paraphrasing, but where the parties have included an arbitration clause in their contract, and they file a court action in breach of that arbitration clause, then the courts shall, a mandatory requirement, stay the proceedings and refer them back to arbitration, unless the arbitration agreement is null, void, inoperable, or incapable of being performed. So it's a very limited scope that the court has to look at. And again, if you look at what the authorities say as to what is a valid arbitration clause, it will say a valid arbitration clause is one that has a mandatory reference to arbitration. So if there is no element of discretion, so if you have a clause that says arbitration, Nigeria, that's a valid arbitration clause, according to the authorities anyway. So in those situations, the court should stay the proceedings unless the arbitration agreement is null, void, inoperable, or incapable of being performed. It is null if, for instance, it is vitiated by fraud. And there's been a recent authority of the UK High Court to that effect, that the main contract was so tainted with fraud that it also affected the arbitration agreement. So that's when it becomes a nullity. Or the parties do not have contractual capacity. One of them is below the age or does not have the corporate status to contract, then it becomes void because you can't enter it. Incapable of being performed, perhaps you have made the appointment procedure so elaborate that you can't find a suitable arbitrator. So you might say an arbitrator who is a chartered accountant, a chartered engineer, a senior advocate of Nigeria, and a retired judge of the United States Supreme Court. You will never find one. So it becomes incapable of being performed. In the vast majority of cases, the court should actually stay and refer the parties to arbitration. In fact, in 2017, there was a practice direction issued by the Chief Justice of Nigeria, the Honorable Justice Walter Onogen, that went even further. The operable legislation at the time, which was the Arbitration and Conciliation Act. Now, the ACA and now the AMA actually gives a judge an option to say, okay, there may be circumstances where we will not refer you to arbitration, null, void, inoperable, incapable of being performed. But the practice directions issued by the CJN said that once a dispute is before a court and the judge sees that the contract has an arbitration clause, it must decline jurisdiction. That's a very strong statement. That is a principle known as negative competence. Now, many of us would have heard of what competence is. Competence in arbitration is the notion that an arbitral tribunal is competent to determine its competence. You are competent to determine whether you have jurisdiction. That's the positive side of competence. It also has a negative side in the sense that because the arbitrator has jurisdiction, the courts do not have jurisdiction. And you would find that jurisdictions that are heavily in favor of arbitration, for instance, France, have the principle of negative competence. So if you compare French legislation to Nigerian legislation, you will see that in French legislation, it says that where the dispute is subject to an arbitration agreement, then the court must decline jurisdiction, not even stay proceedings, decline jurisdiction unless the arbitration agreement is manifestly void. Very strong, very high standard. Manifestly void is you look at it, and just by looking at it, you can tell that something is wrong with the arbitration agreement. So they rarely do. And guess what? One of the most favored jurisdictions for arbitration is France, because of the judicial attitude in support and in favor of arbitration. So I think if we want to reach that promised land, we have to ensure that we have not only legislative reform, but we need a reform of the way we approach these disputes, primarily from counsel, because it is counsel that will advocate these positions before the court, but also on the part of the judiciary in terms of being sympathetic to the arbitration procedure. In fact, there was. Please tell me if I'm talking if I'm going too long. I'm very passionate about this subject, and many things are coming to my mind now.
Now we've always understood that this section is going to be dynamic, and the more you move, the more you make us understand the nitty-gritties behind the act, the better it is for us.
Okay, so you're saying I'm free to continue?
Absolutely, Nenensik.
All right, thank you for that license. So there's a very pertinent decision of the Australian High Court. Sorry, not a decision, a speech given by, I forget their title, but the equivalent of the Chief Justice of Nigeria, the highest judge in Australia, said that in terms of the interface between arbitration and the courts must learn from the phrase international commercial arbitration. International in the sense that your decisions, although made domestically, have international repercussions. So the decisions we are making here in Nigeria will be discussed and debated internationally. If they're good, it will attract more people to this jurisdiction to arbitrate. If they are bad, we will get a reputation as being a jurisdiction that does not support arbitration, right? Commercial is the second one. So the court must understand the commerce behind the transaction. So if you think, for instance, of the UK decision in Fiona Trust, where they said as a matter of business common sense, if the parties have an arbitration agreement in their contract, then it means that their intention from day one is that every single dispute that arises from that contract want to be submitted to arbitration. So the courts will rarely interfere because they understand the commerce behind the party's intention. And don't forget that the data shows that international businesses favor arbitration over litigation. And then the third element is arbitration in the sense that you must be sympathetic to the process of arbitration by not only, by two things: understanding the law and practice of international commercial arbitration, so understanding the provisions of the Arbitration and Mediation Act, and applying it to the circumstances to ensure that the objectives of the Act are fulfilled. So the interface between arbitration and the court is extremely critical. It's almost a paradox. In fact, Jan Paulsen described it as a paradox because on the one hand, the parties are running away from the courts and going to arbitration. And on the other hand, arbitration cannot survive without the courts. So really, we have to ensure that matters that should go to arbitration actually go to arbitration. And likewise, matters that should not go to arbitration should not. It's a two-way thing. We shouldn't be overcompensating to say, oh, because we want to be seen as an arbitration-friendly jurisdiction, you are now referring matters that should not go to arbitration to that process because you will prolong the parties' dispute. Let me give you a practical example of that. There is case law in Nigeria that says matters of taxation are not arbitrable. And the courts, in a series of decisions, were very careful to distinguish between what is a contractual dispute that can be submitted to arbitration and what is a tax dispute that is meant exclusively for the Federal High Court. If the if time permits, we can discuss that. But knowing what the law is critical, because if the court sends one of those disputes to arbitration, automatically you have prolonged the dispute, because the losing party will challenge to say taxation is not arbitrable before under Nigerian law. And based on the Court of Appeal decisions, they will succeed, meaning that they would have spent a lot of time, money, and resources in the arbitration process, only to have the decision set aside because of a lack of understanding of the law and practice of arbitration in Nigeria. So many other things to be said, but I would still love us to touch one or two other areas to make the conversation as wide as possible. But I hope that answers your question.
Thank you, Leonard Sig, for that far-reaching insight. Thank you so much. We never expected anything less. Please, at this juncture, I would love to bring to the attention of our esteemed participants that we are live, we are streaming live on YouTube. The link is there. And Leonard Sig, permit me to read one or two comments. When we were looking at apathy towards ADR from the side of the court, someone dropped on the chat box, the problem is not the judges, but lawyers. Do you want to react to this?
Yeah, so I actually said so in the course of my intervention. I said that it is the lawyers that are advocating these positions. So yes, there is a lot of blame that lawyers should shoulder, and I fully accept that. Nevertheless, I have seen situations in which the lawyer will try to be tactful in order to frustrate the proceedings, and the judge will have none of it, right? So I won't mention judges here, but I can commend some extremely good decisions of both the High Court of States and the Federal High Court, in which the judge had a clear understanding of the process and said, no, I'm having none of this. I will send you back to arbitration. And in fact, if one applies the practice direction from the Honorable the Chief Justice of Nigeria, the court, in sending back the parties to arbitration, should actually apply that practice direction in its full spirit and award damages for breach of contract. That's what the practice direction says, because if you commence litigation in breach of an arbitration agreement, that is breach of contract. And damages, according to the authorities, are the ordinary and natural consequence of the breach. So if I've spent money to come to court to defend this, then I should be awarded costs on a full indemnity basis. And a lot of judges do that. On the flip side, and I'm very sorry to say this, I've also seen decisions that do not support the arbitral process. For instance, I'm aware of about 5 current decisions, and again, I will not mention any jurisdiction, that have issued injunctive reliefs restraining arbitrators from continuing with arbitral proceedings. And one was so bad that in another discussion we had, an international arbitrator stated that they had such a bad experience that they will never recommend Nigeria as a seat. So again, recall, I said decisions locally have international repercussions. And that is what we need to be wary of. And how do we ensure that we don't fall into this situation? Discussions such as these, discussions organized by the Association of Multi-Law Courthouse Practitioners, the ICMC, mediation enthusiasts, arbitration enthusiasts, dispute resolvers, to ensure that the broad majority are aware of what the law and practice of not only commercial arbitration, but ADR is, to ensure that we are giving effect to the spirit and intent of the parties' agreement, which is a position under Nigerian contract law. The courts exist not to make a contract with parties, not to advocate for one of the parties, but to give effect to what parties have agreed contractually. So if they have agreed to a different forum for the disputes, then the courts ought to give effect to that. And I'm foreshadowing what some comments might be. A counter argument might be that, well, are you saying that the parties can agree to out the court's jurisdiction by going to arbitration? No, I'm not suggesting that at all. In fact, there are decisions of the Supreme Court, most recently in, I believe, UBA versus Trident, that says an arbitration agreement does not amount to an ouster of the court's jurisdiction. The courts are only given effect to what the parties have agreed contractually. And that decision is open to challenge nevertheless before the court. So it is no way an ouster of the court's jurisdiction. So I think we are all in this together, both the bar and the bench. And I think we have to be very deliberate in our efforts in advocating ADR practices to the bar, which is very critical, and to the bench. In terms of what we are doing, I currently chair the ADR committee of the Nigerian Bar Association section on legal practice. And one of our critical mandates is capacity building sessions. The first we had this year was a collaboration with the High Court of Enugu State, and that was in relation to court-referred mediation. The second we had was a webinar on arbitration, discussing a lot of the problems we're facing. In fact, the question we were trying to interrogate was whether arbitration has lost its value proposition because of recalcitrant tactical litigation that is aimed only at stifling the arbitration. And we will be having several more, and I really commend them. And the arbitration community is also having a discussion with the National Judicial Institute for the purpose of having, as part of the curriculum, both for newly appointed judges and a refresher course on an annual basis for existing judges, some curriculum that is arbitration and ADR focused. So we are all aware of what the current practice and procedures are in order to mitigate the negative effects of tactical litigation to frustrate ADR.
Thank you so much, Leonard Sig. It is true that there's so much to give out, but trying to streamline our focus. I know you've touched on this in your presentation, but please let us make it much more specific and elaborate. Looking at the Arbitration and Mediation Act 2023, what are the provisions of the Act that is a plus to ADR, looking at Nigeria as a jurisdiction? Are there provisions of the Act that has placed our jurisdiction at par with other advanced jurisdiction? That is one side of the question. And if you don't mind, the other side of the coin, what is your projection like? What do we stand in the nearest future being at par with other jurisdictions? Do you think that Nigeria can become an ADR hub in Africa and in the world at large?
Okay, thank you again. So yes, I did touch on this earlier. Because the Arbitration and Mediation Act is based on the 2006 Armstrong Model Law, it has raised Nigeria to the level of what is the gold standard internationally. And of course, the Arbitration and Mediation Act continues to apply the New York Convention for the recognition and enforcement of foreign arbitral awards. So from a legal framework perspective, we are at par with international standards. The AMA also has provisions that are not contained within the Armstrong Model Law, but nevertheless, in my humble view, advance Nigeria as a favored seat for arbitration. So for instance, emergency arbitration proceedings. Emergency arbitration is a situation where you want an interim measure, right? But it is so urgent that you cannot await the formation of the arbitral tribunal. So in which case you will go to emergency arbitration. And many international arbitration rules have it. So the ICC, the CIA, the AAA in America, the Swiss Chamber of Commerce, etc., etc. It also has proceedings for joinder and consolidation, which I alluded to earlier. The Ostrom model law doesn't have that. And so it looks at the peculiarities of what we are facing in Nigeria and gives, at least from a framework perspective, a means through which we can mitigate the risk that you will hit a hurdle in the proceedings down the line. Now, that's the framework. Do I foresee Nigeria being an arbitration hub? It depends. And yes, that it depends is an answer that lawyers like to give, because it's very dependent on circumstances. Having a modern arbitration law is not enough. Many in the audience might be members of the Chartered Institute of Arbitrators. If you recall, CIR brought out what they called the London Centenary Principles that set out a list of what a viable arbitration seat should have. So yes, you need a modern arbitration law. You need a pool of experienced arbitrators. You need a pool of experienced counsel, legal practitioners. You need modern facilities through which you can carry out an arbitration process. You need security in the infrastructure. There was I don't know if to call it amusing or alarming. It was, I believe, in Pakistan, one of the Central or East Asian countries, where one of the parties did not want the arbitration to continue or to progress. So what happened? The arbitrators were kidnapped. So you can imagine in a jurisdiction like that, many people will not be comfortable to go there. So you need security. You need ease of access. If you are a foreigner, you need a letter of invitation to even enter Nigeria. So that's an additional barrier to say you want Nigeria to be an international hub. Yes, there are now visa and arrival processes and procedures, but it's still quite complicated. Many colleagues I know internationally say they prefer the safety of having a visa stamped in their passports than to come and risk visa on arrival and they'll hear another story, right? Now, compare that to a jurisdiction like Kenya, which is also fighting to become an arbitration hub, or Rwanda, which is also fighting to become an international arbitration hub. What do? Rwanda has made access to their country visa-free for all 53 other African countries. Kenya has removed formal visa requirements. You now need something called an electronic travel allowance. You fill in a form online, and that's the only thing you need. Once it's approved, you can travel. So they are making it easy for businesses to thrive and creating a viable environment for arbitration and ADR services to support those businesses, access to justice, right? When the disputes arise. And until we get that formula correct, try as we might, we simply will not be able to compete with the other seats that are doing what they're supposed to do in terms of not only having the law in place, but making the environment such that arbitration and ADR are conducive and fit for purpose. Because the last thing you want, believe me, is to start the process and then halfway down, it stops, it is stifled. It's a waste of time, it's a waste of money, and it's not what a business wants. So the jury is out. A lot of it is down to us, the practitioners, in terms of how we advance ADR processes, in terms of how we support ADR processes, and very critically, the courts for all the reasons that I've stated. So I'm hopeful. If I was not hopeful, we would not be advocating as much as we were. And if you were not hopeful, you would not be advocating for as much as you are as well. So I'm glad that we are in this conversation together. And I hope that we can make the community and expand the conversation to include an even wider audience, because it will only take us one step closer to where we want to be.
Thank you so much, Learning Seek. We deeply appreciate your response and thought-provoking explanations. Please, Noble Lord, Your Excellencies, highly esteemed participants, feel free to drop your comments, your concerns on the chat box. We will soon make the room open for direct conversation. Learning Seek, I would love to bring some comments on the chat box to your notice. If you don't mind, you may choose to respond to them now or much later. From Honorable Justice Onibokun. Then let's see, can you repeat the titles of the 1985 and 2006 laws? Thank you. I wouldn't know if you want to.
Yes, I was referring to the UNCITRAL model. UNCITRAL is the United Nations Convention on International Trade Law. What they did in 1985 was to come up with a single document that is reflected in international best practice as what modern arbitration laws should contain. So the model law in itself is not actually a law, it's a template that countries can adopt and adapt for their purposes. But in order to be considered to be a model law jurisdiction and therefore reflect international best practices, then that law must contain, your country's law must reflect a minimum of, I believe it's 70 or 80% of the UNCITRAL text. So the first version was made in 1985, and there was a new version, an updated version that was made in 2006. And in fact, there were some other versions that were made, I believe, in 2014, but it concerned primarily investment arbitration. So the text I was referring to is the UNCITRAL model law, and it's a template that countries can adopt, and it's pretty much a ready set series of provisions that tell the international community that you have a modern arbitration law, and again, enhances the predictability. In theory, enhances the predictability of your jurisdiction. I say in theory because in practice, we must ensure that the way we apply those provisions are consistent with the intent. So if you look at the UNCITRAL text, there's something called the travaux préparatoires, the preparatory documents. It explains article by article what the intention behind each clause is. So if you were to adopt those clauses in national legislation, in order to ensure consistent application across different jurisdictions, then really the application should align with the travaux préparatoires. Maybe what would help is if the UNCITRAL model law is readily available on the internet. If you simply Google UNCITRAL model law 2006, you will see it. But I will happily make available a copy to the organizers to disseminate to the audience. And I will also make available the travaux préparatoires, which explains bear in mind it explains the 1985 version, but many of the provisions are the same. There are some additional provisions, but what you will see is that in the UNCITRAL text itself, it has explanatory notes that explains the intention. And I think that will go a long way in ensuring that we have consistent and efficient application of these provisions. So thank you, my lord, for raising that question.
Thank you so much, Leonard Sick. I wouldn't know if I'm correct to say you have some form of not just intellectual but spiritual foresight, because I was to say after your response to this question that participants who wish to get the recording of this webinar should do well. Drop your email address, your full name, and your email address. Feel free to include your phone numbers so that we can get the recorded version across to you. And courtesy of our special guest, beyond the recorded version, there are other materials that will be disseminated to you. So please do well, all participants, drop your name, your email address, and your phone number. We'll do just that. Let me pick a comment from the chat box from Gambo Abubakar Sadatu. How would you react to the argument that matters under the Matrimonial Causes Act should not come under ADR, particularly mediation, because it is seemingly flouting the Matrimonial Act? How does AMA 2023 address issues like this? From Sadatu Abubakar Gambo, Director, Niger, either Niger or Nasarawa, please permit me, but Nasarawa State Multi-Docked House. So this question is coming from the Director of the Multi-Docked House here in Nigeria, either Nasarawa or Niger. We appreciate your response.
Thank you. That is a great question. And there are many aspects that it opens up, and I'll do my best to answer it as clearly as possible. Now, regarding arbitration, the first thing you have to advert your mind to is, what is an arbitrable dispute? When is a dispute capable of being subjected or submitted to arbitration? Primarily, it must be a commercial dispute, right? So again, what is a commercial dispute? The Act defines it in a very broad and general way, but that definition will not accommodate the matrimonial cause for arbitration, right? If you'd want to know what is what is capable of settlement by arbitration, very old Supreme Court decision in Kano State, the Kano State Urban Development Board, Fans Construction versus Kano State Urban Development Board, gave a definition there to say that if the subject matter of a contract, if a subject matter is capable of being compromised by a party through contract, through agreement, then generally speaking, it is capable of arbitration. Now, a matrimonial clause, presumably to end in the dissolution of a marriage, because of the way the Matrimonial Causes Act is framed, is not capable of being compromised by way of accord, by way of agreement, because you need a decree from the courts to have that marriage dissolved. Decree nisi in first instance, and decree absolute, right? So we can't say, I agree to have a decree absolute. Legally speaking, you will still be married. Now, what about mediation? There are aspects of a matrimonial cause that are very susceptible to mediation, and I've done several of them. Now, whilst the decree itself is the subject to the court's order, the court's pronunciation, the terms of that decree is capable of being agreed between the parties. For instance, maintenance and support of a spouse, maintenance and support of children, access to children, several other things. So we've done cases in which we've agreed to say, okay, the parties want to separate. The divorce is uncontested. We now agree to say, well, we don't want the proceedings to be raucous because it will affect the nature, it will affect the outlook of the children. We don't want the children to look back in the years and say, oh, it's daddy's fault or it's mommy's fault, right? So they come together, they agree amicably to say, we will have joint custody of the children. This is how we will have access to the children. This is how we'll provide for the school fees. This is how we'll provide for health insurance. This is how we will support one another, right? And we have submitted that before the courts. The parties will come to the court and say, yes, this is our agreement. And the courts have accepted it. So the court will do the decree, nisi, on the terms that the parties have agreed regarding how those nuances will occur. So I hope that answers your question. In terms of the jurisdiction, we've done that severally. It's the FCT. So I don't know how other jurisdictions would approach it, but I think it's a very sensible approach. It frees up the court's docket. First of all, you don't have to go through, if you've gone through contested divorce proceedings, it is very acrimonious. It is very tedious, tasking mentally and physically. And if the court could have an opportunity to free up some time to deal with matters that are equally deserving, if not more deserving of the court's time, then I think it should take it. So I would advocate for that. So arbitration, not so much. Mediation, very amenable, is how I would answer that question. And you sought my opinion, and so I hope I've been able to answer it in a way that is acceptable to you.
Thank you so much, Learned Sikh. Making reference to participants, noble lords, your excellencies, highly esteemed participants, please, while we make moves to draw curtain to today's webinar, please, if you wish to make any comments or make your thoughts known directly to our special guest, please use your virtual hand, raise your virtual hands, and in due time, we will accord you that attention. We are live on YouTube. The link has been dropped on the chat box. We have a comment. And by way of to reinforce this information, please do well to drop your name, email, and phone number on the chat box. We will get you the recording of this webinar. Learned Sikh, we have a question. Matrimonial issues are mostly sensitive and best for confidentiality that is connected to ADR. Please, I need your reaction on this.
In terms of whether I agree, well, yes, there could be many sensitive aspects that would be amenable to ADR. Certainly, but bear in mind that once you, in terms of how you would sort of navigate those confidential aspects of it, theoretically, you could go to the courts, have an uncontested divorce, if that is at all possible, and obtain a decree nisi, and eventually a decree absolute, but have a separate agreement between the parties as to, again, access to the children, monetary support, and what have you. I would prefer, in the long run, to have that back in the judgment of the court, just for enforceability purposes. But could I see a situation where there could be some confidential issues that you would not want made public? Absolutely. But maybe given the personalities involved, they may not want to air out their dirty linen in public. The financial amounts involved, we know what the situation is in Nigeria. You might not want that to be public knowledge, which will attract unwanted attention. So yes, I agree. There are many aspects of not just matrimonial causes, of other matters that the parties would like to keep confidential, and certainly would be amenable to an ADR process. But bear in mind as well that the fact that you submit it to ADR doesn't make it automatically confidential. It makes it private. It might not make it confidential. It depends on what the law in a given jurisdiction is. So again, I don't know why I'm referring to Australia or not, but many examples are coming out from there. There's a very famous decision called ESO Australia versus Plowman, where the Australian courts said that there is no automatic right of confidentiality to arbitration proceedings in Australia. The parties must specifically state in their agreement that the arbitration is confidential before it enjoys that air of confidentiality. Contrast that to English law, which makes the presumption automatic. There is an automatic presumption of confidentiality in the arbitral process. What's the situation in Nigeria? Law is silent, actually. But the consensus amongst practitioners is that, again, there is the proceedings carry a presumption of confidentiality. But just bear that in mind. If you want to make absolutely sure, state it in the contract that the ADR process is confidential. Avoid any nasty surprises is what I always, prevention is better than cure, as they say.
Thank you so much, Leonard Sig. I will just take one comment from the chat box, then let's see how we can take one or two questions from the call. Please do well to raise your virtual hand if you wish to make your comment directly to our special guest today. There's a comment from Benjamin Fatogun. The problem I have most times in my practice in mediation is with lawyers. A lot of lawyers think it will affect their practice, their fees, and most of them believe they must win to impress their clients. Most cannot understand the win-win situation regarding alternative dispute resolution process. Thank you so much, Benjamin Fatokun, for expressing your thoughts. Then let's see. Permit me to pose these twin questions. Some school of thought believes that ADR should be restricted to legal practitioners solely. Some school of thought believe, as it is in some jurisdictions, that it would be great to have on the call facilitating ADR processes a legal practitioner and a non-legal practitioner joining forces to pilot an ADR process. How do you react to these two schools of thoughts?
Okay, so ADR, and in specifically arbitration, was developed by lawyers, actually. Arbitration was developed by merchants. Merchants believed that the best people to resolve a dispute between themselves was somebody who understood the nature of their business. So they will get another merchant who was the neutral to give a binding determination of that dispute. And that's how it started. Lawyers, as lawyers tend to do, have entirely taken over the process. So that should give you a hint to the first question. I do not think that arbitration or ADR should be the exclusive preserve of lawyers. I think it would suffer for that purpose. The second question, do I think it is advantageous to have lawyers and non-lawyers? Again, it depends. Certainly, if there is a legal question involved in the dispute, then it would be beneficial to have a lawyer. But you might not even need a lawyer at all. It could be a panel of non-lawyers. It could be a mixture of both. It could be a panel made up entirely of lawyers. Irrespective of what the panel makeup is, the principle remains the same: to ensure that the parties have a just, fair, and prompt means of resolving their dispute, right? But I don't think it should be the exclusive preserve of lawyers. In fact, I recall when I had my peer interview to become a chartered arbitrator with the Chartered Institute, I faced a panel of 3 practitioners, none of whom were lawyers, and each of whom were chartered arbitrators. It was a virtual conversation. I was in Abuja. The other one was in Ireland. The other 2 were in London. None of them were were lawyers. I think one was an engineer, one was an architect, and the other I forget, but certainly not a lawyer. And the questions that were asked, you could tell that the experience was significant. So I think the process benefits from opening it up to practitioners in fields that involve disputes, whether they be engineers, whether they be architects, whether they be quantity surveyors, whether they be lawyers. It really depends on the nature of the dispute. And that's one of the beauty and advantages of ADR. You have the flexibility to appoint a neutral that is best suited to your dispute, whether that person is a lawyer or not, or a lawyer and an engineer. It's really up to you.
Thank you so much, Leonard Sig. Your disposition and zeal towards the propagation of ADR in our jurisdiction is amazing. I had the privilege of listening to you when you were on the call on the platform of NICAB, looking at the AMA 2023, and the interface you had with the ADR audience in Enugu. I was also privileged to attend that particular discourse, and here we are again today. Thank you so much. We know there's hope for our practice. Robinson Onoa has this to say: I agree with the speaker. We can mediate on the auxiliary issues. In divorce cases which I have handled in Delta State, for instance, settlement of properties, children welfare are taken into consideration. Please permit me to also read this comment from our highly esteemed, my Lord, Honorable Justice Rolly Harriman. In Delta State, 90% of divorce matters are sent to the multi-door court house for negotiation of ancillary reliefs. As Lenin Singh has said, this is the way to go. From our highly esteemed, no other than Dr. Agada John Elachi, SAN. Brilliant presentation, my learned friend of the sick. We are glad to have everyone on the call. For the record, this is the second series of our webinar on the platform of Association of Multi-Door Court House Practitioners. We appreciate everyone for pulling resources together to make today a reality. Before I take more comments on the chat box, and before I give attention to virtual hands that may have been raised, let us see, permit me to ask this question. Your role, contribution, impacts in ADR cannot be overemphasized. Please, at some point, you may not have been attuned to ADR, but here you are championing the cause aggressively and massively. Could you explain, let us in, at what point did you accept ADR? What brought you into the field of ADR? Permit me to say, when did you become a born-again ADR practitioner?
That's an interesting way to put it. Well, quite early on in my professional career. So my master's degree was actually had elements of arbitration and mediation in it, although it wasn't related exclusively to arbitration and ADR. I was encouraged to do so by another very highly esteemed judge in the High Court of Delta State. And I thank my Lord, the Honorable Harriman, for that question. And I thank my Lord for also joining in. But I was encouraged to do arbitration by my Lord, the Honorable Justice Akpovi, who is also on the bench in Delta State. And I'm proud to say we have very many judges that are sympathetic to arbitration and ADR on the bench in Delta State, my Lord Justice Harriman being a prominent member of the bench as well. So I did that in 2006. And so 2005, sorry, from 2005, that's when I did my first master's degree. And then I worked after law school. I started as NYSC counsel in the chambers of Patrick Ikweto, Senior Advocate of Nigeria. And primarily it was a litigation firm, but Mr. Ikweto also was involved in arbitration mainly. And it was in that office I decided to take a course with the Chartered Institute of Arbitrators, became an associate member, and started applying some of the things we learned academically. So initially, when he was appointed as arbitrator, he would appoint me as tribunal secretary. So I would see the proceedings firsthand, and I got to know what the nuances were. I did that for a few times, eventually took my first appointment as counsel in an arbitration proceedings. By God's grace, it went extremely well for the client, such that your client becomes your best advocate when you do good work for them. And they referred more arbitral cases my way, did a few more as counsel, until eventually I started becoming appointed as an arbitrator. And these days I'm appointed more as an arbitrator than I am as counsel, although I enjoy the role of counsel more than I do the role of arbitrator. I mean, they're both wonderful, but from an advocacy perspective, I tend to prefer the role of counsel. And I'm sure my learned brother and very, very dear friend, Agadai Lachi, would agree, although he's a very well-known and esteemed mediator and arbitrator himself. So that's how I got into it. It was a very long process. Started way back in 2000. I recall I didn't really get my first appointment until around 2012, I think. My appointment as registrar, tribunal secretary. I started getting that from around. I mean, the serious ones. I started getting that from around 2010, 2012. My first appointment as counsel on my own, not as co-counsel, was in 2017. My first appointment as arbitrator was a little bit before that. My first international appointment in an ICC arbitration was in 2020, 2021. So it was way, way down the line from 2006 where I started. So it's been a very eventful journey. I'm very grateful for the opportunities I've had, for the people I've had an opportunity to interact with, and for the role we continue to play in the arbitration process. It's a community I'm very proud to belong to because I get to meet very esteemed practitioners, and I get to learn, more importantly, from very esteemed practitioners, including today. So thank you very much for this invitation, opportunity to share one or two thoughts with this very distinguished audience.
Thank you so much, Leonard Sig. Quite an amazing story. And I do hope this will inspire non-ADR practitioners that there's need for us to join forces together. There's a message on the chat box from Sewese Yaji Ando. Forgive me if I misplace your pronunciation of your name. Can the NNC please shed more light on the binding and enforceable nature of mediation as contained in the AMA 2023? Does it make mediation less effective compared to arbitration? I think it's a 2-in-1 question.
From experience, I actually find mediation has been more effective than arbitration because it is less adversarial. Arbitration can be very adversarial. And the more adversarial it is, the less inclined the parties are willing to accept the outcome. So you would find, I'm sure, if you ask many practitioners, that a very high percentage, and I won't give a number because I prefer to use actual data, but I suspect that a very high percentage of awards will be challenged before the courts. Whereas if you have a mediated settlement, then the parties are already agreed as to what the outcome would be. And it is binding and enforceable in the sense that it is now a contractual document between the parties that is capable of enforcement. Happily, and recently, there has been the Singapore Convention for the Recognition and Enforcement of Mediated Settlements, which is the equivalent, if I can call it that, of the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. What the Singapore Convention does, and Nigeria is a signatory to that convention, is it facilitates the enforcement of settlement agreements. So you can take your settlement agreement from Nigeria and go and enforce it in other jurisdictions that are also party to the convention. So I think increasingly we are going to see the rise of commercial mediation as a very viable aspect of commercial dispute resolution. From experience, it tends to cost less than arbitration, significantly less in terms of money, in terms of time. So I suspect mediation in the coming years will be a more attractive proposition to parties than arbitration will be. That is not to say that arbitration is less useful. It certainly will still have its use. The numbers of cases that are submitted to arbitration tells you that if you look at caseload statistics from international arbitration institutions, you will see that, I mean, some years may be more than others, but generally speaking, there is a high number of disputes that will be submitted to arbitration. And that's just because of the psychology of disputes. The way a dispute will naturally evolve, it will pass a stage where the parties are amenable to having an amicable settlement. You may be able to get them back, but once you cross a certain threshold, it becomes very difficult because egos get involved. Ego and disputes do not mix very well because the parties stop thinking rationally and start saying, well, even if I go to court, even if I go to arbitration, I just want to show you, teach you who's the boss. So I see merits to both of them, but from experience, I find mediation to be the more attractive proposition for commercial partners that prefer speed and efficiency. That's my experience. Others may have different experiences which are equally valid.
Thank you so much, Leonard Sick, for that response. There's a comment or a question on the chat box from Evelyn. She wants to understand what should be done when a party submits to mediation and the other party refuses to submit to mediation, either in a working scenario or in a court-referred scenario. What should be done?
Very interesting question again. So for court-referred mediation, this question actually came up in Enugu in the conversation we were having there. And I think one of the outcome we resolved to do was to draft sort of a template practice directions for how the mediation proceedings would take place and continue after the court has referred it. And the question of a recalcitrant party came up. But because of the consensual nature of mediation, it can be very difficult to compel. If one party does not want to mediate, you can't force them to because the mediation will lose its character of consent. So that's one thing that may come against it. What you might want to do is use different techniques. For instance, to give the parties a reality check as to say that it might not actually be in your best interest to continue in a stance that is disruptive. So usually if there's a business at stake, you give them a reality check as to what the actual costs are, not just in terms of money, but in terms of time, in terms of resources, personnel resources that could be used for other things to innovate and drive your business is being used for a dispute. It's not efficient. So I think the best way to go is the continued advocacy once parties are aware of what the advantages of mediation are. The hope is that they will themselves come around to say, okay, well, I have better things to do than to either litigate or continue this dispute. There is only so much you can do with legislative or other types of frameworks. The framework will give an avenue through which you can apply it. The application is a different thing. For mediation, you can't compel because it's a voluntary process. Is that a weakness? Not necessarily, because it is the fact that it's voluntary that makes the parties more acceptable of its outcome. So I think the key is to be skilled as a mediator. And I'm thankful that very many esteemed colleagues are on this call who will explain it in a much better and a more succinct way than I have. And I'm sure that they will continue, including the ICMC, continue to advocate for mediation training, capacity building, which is what we all need.
Thank you, Leonard Sick. Now, please let me appreciate our noble lords, highly esteemed, Your Excellencies, for joining into this webinar. Your presence added tremendous value to this session and interaction. Please feel free at this point to raise your virtual hand if you have some issues to raise or you have contributions to make as we draw the curtain on this exciting presentation. Before we call it a day, it will be injustice to ask you, dear Leonard Sake, how has the journey been so far in the ADR space? You wish to share some of your high moments or your low times? What are some true life stories you want to share with us? We'll be glad to hear it all.
Okay, well, I'm limited as to what I can share because of the nature of arbitration proceedings. But there was an amusing story that I will share. It was my first ICC arbitration, and you had the claimant was from a company from Uganda. The respondent was a company from Tanzania. The seat of the arbitration was Nairobi, so Kenyan law was governing the proceedings, and it was going very well. We had our first procedural meeting, set dates for the hearing, booked all the necessary support processes on ground in Nairobi, and then COVID-19 happened, shut everything down. Initially, we didn't know how long it would last, so we agreed to push the proceeding. It was initially supposed to be in March. From March, we pushed to May. From May, we pushed to July. From July, we pushed to August. And eventually, the parties, upon my you have to be very careful not to plant decisions in the parties, but based on my nudging, we eventually agreed on a virtual proceeding. And I suspect it may have been one of the very first to have taken place on the African continent that was fully virtual. So we had to do a lot of improvisation, and I had to ensure the proceedings were managed in a way that is efficient and aligned with the ICC rules of arbitration, which was also applicable. So we were going along in the virtual proceedings, and it started quite well. We managed to do 2 test calls. Everything was good. And then the weekend before the hearing, Respondents' Counsel sends an application through email that they wish the witnesses to be cross-examined in Swahili. And they said that because the witnesses are not very versed in English, it would be an obstruction to fair hearing. So it's not just Nigerian lawyers that raise issues of fair hearing. It would be an obstruction to fair hearing, that magic wand that cures everything, apparently, if they are not cross-examined in Swahili. Naturally, Claimants' Counsel had a strong objection. For me, the arbitrator, you have to balance it very carefully because the due process requirements require you to give each party a reasonable opportunity to be heard. And if you do not, then it would be grounds for setting aside the arbitration award. So I'd look very carefully at the documents, look carefully at the contract, and I declined the application for a number of reasons. Firstly, the contract was in English. All the contractual exchanges, emails, everything was in English. The parties' witnesses gave statements in English. And in their witness statements, they said that they had read and understood all the contractual documents, which were in English. It would have extended the proceedings significantly in terms of time and costs if we now had to firstly adjourn, because there's no way it would have been, the application was made on a Saturday, the hearing was on Monday. We would have needed to get an interpreter to translate live from English to Swahili and vice versa from Swahili to English. And so we would have had to pay for that interpreter. We would have had to pay for the transcription in Swahili and English. So ultimately speaking, there were more reasons to refuse the application in terms from an efficiency standpoint and ensuring that the parties will still be able to present their case. than we would have gained from allowing that application and allowing them to, funny enough, give evidence in chief in English because the witness statements were in English, and then being cross-examined in Swahili. So that was one where I had to ensure that the reasoning was very clear as to why I was refusing that application. And happily, the ICC court, ICC has this process where they will scrutinize a draft award before you make it final because they don't want their awards challenged or set aside. They will not write the award for you, but they will point the areas where they think you should fill in the gaps and answer. And happily on that point, they were in full agreement. So that was that story always amuses me, and hope you found it to be of interest as well.
Thank you so much. Reading out the comment from Ozioma. Thank you very much, Learned Sikh, for this insightful interaction. God bless you. Thank you very much, organizers, for putting this together. I want to appreciate everyone, noble lords, your excellencies, highly esteemed ADR practitioners, for staying with us these 2 hours. It has been exciting. We have few seconds to give audience to as many that may want to interface and interact or speak freely with everyone on the call. If you wish to speak, make your comments, please raise your virtual hands and we will accord you that opportunity. While we wait for anyone on the call, permit me to ask this question, Learned Sikh. ADR and ODR becoming so effective. What is your take on the future of ODR in ADR? What are the possible challenges and how can we submit them?
Yeah, it's inevitable. We will increasingly see ODR practices involved. ODR is online dispute resolution. Just for, I presume everybody in the audience knows that, but just in case, it stands for online dispute resolution. So increasingly, you will see ODR practices being incorporated in ADR proceedings. For instance, I'm currently involved in an arbitration in Nigeria where all processes preliminary to the actual hearing are being conducted online to save costs. It is only the actual hearing, because that's the way the parties want it, that will be physical. But there's nothing stopping us from having an entirely virtual process if the parties agree to it. You see that in courts as well. The National Industrial Court has taken up ODR significantly. A lot of their proceedings are done online. If you belong to the Industrial Court's WhatsApp group, you will see regular links to view court proceedings. In the High Court of Delta State as well, I know that the Honorable the Chief Judge has started taking steps to implement virtual proceedings before the courts. And it's only a matter of time, and I hope that it will be very receptive, that it will pick up. In terms of the challenges, there are many. Infrastructure is one. You would have a situation where internet connectivity is not the best. Connection to electricity might be unreliable or unstable. The connection, some advocates say that they would prefer to be in a physical room with the arbitrators in order to gauge their reactions. You might lose that personal time. I don't have that, because really, if somebody's in front of a camera, you can pick slightest changes in demeanor. So that's perfectly connected issues can be a disadvantage. Can also be a disadvantage if you have, and I've experienced this, a witness will not quite understand. It can slow down the proceedings, because in a room, at least you might be able to hear them better. But virtually, particularly if the connection is not great, it can be very difficult. can be very difficult to hear them. But that is not to say that these are problems that are solvable. If I have internet connection, hardwire connection plugs directly to my computer, and I have two backups that are Wi-Fi. I have three different means of power supply: AEDC, which is the NEPA, if we can call it that, an inverter, and the generator. So the important thing is to sort of understand what the limitations are. Wow. And ensure that you have mitigating factors in place to ensure that those things do not disrupt the proceedings, because the key is to ensure that you have a synchronous exchange. You can hear me as I talk and you can see me as I talk. That's the key, really. And once you can have that, it can be very simple.
Thank you so much, Leonard Sick, for making yourself valuable. I want to appreciate everyone on the call that stayed till this point. Do well to drop your name, phone number, and email address if you're interested in getting the recording of this webinar. We do hope in our next edition, we have everyone on the call join us to make it a worthwhile experience. Let us see, I don't know if within 30 seconds you can help us with this. If you have the opportunity again to participate in the drafting of a new law as regards ADR, what will you do better, or what will you refrain from doing?
Interesting question. So know the full extent to plan. You will tend to see what the limitations are after a number of years of operation. So I'll be in a better position. What I would like to change is not by council, our colleagues, and to some the courts as well, to ensure that there isn't a gap between arbitration policy and arbitration practice. That's where the problems tend to happen. I was asking a colleague, and they say arbitration is fantastic.
Now let's see, we can't hear you.
Their impression of it. Sorry about that. Can you hear me now?
Yes, yes.
Okay, my apologies. I was saying that I wouldn't necessarily change the text yet anyway, because I'm sure that it is consistent with the spirit. So that is what I.
Thank you so much, Leonard Sick. I do believe.
I hope I'm still audible.
Yes, yes, yes. I do believe we've had a very insightful, thought-provoking session from my Lord, the Honorable Justice Roddy Harriman. Thank you so much, Leonard Sick, for this eye-opening webinar. The ADR Award is grateful to you. And please permit me to use the words of Ambassador Segun Oguyomo. You are a great man, and we appreciate you. Noble Lords, Your Excellencies, highly revered ADR practitioners and ADR enthusiasts, it has been awesome being with our very own Bozimozaya SAN. Thank you for giving us your all. Thank you, and thank you. Till we come your way on the platform of Association of Multi-Door Courthouse Practitioners, on behalf of the convener, Sir Valentino Bureau, and everyone on the call, please, we appreciate your time. The link to become a member of the association has been dropped on the chat box. Do well to use the link to join us in, and do well to register for the ADRO training coming up on the auspices of School of Alternative Dispute Resolution. It's an executive program, virtual, in the month of June. Please do well to join us. We lack words to express our appreciation. Thank you so much for making it out with us today. Thank you, thank you, thank you, thank you so much. Let's say thank you. We can't thank you less.
Thank you so much. I'm grateful for the invitation. Everyone for staying on the call. My lords, esteemed colleagues, thank you so much. And I'm hopeful that we'll do this again soon, and hopefully see you physically so we can have more interactions. Thank you very much.
Thank you so much. So with this, we've come to the end of this interactive section, very interactive, and 9 minutes behind the planned time. I know we never regretted spending these 2 hours, 10 minutes on this webinar. Till we come your way again. Stay blessed and keep advocating and advancing the ADR world. Thank you.